Good morning. So we'll get things underway. Again, thank you for joining us today on our next of our webinar series, which has proved quite popular. Today, we are going to be discussing client vulnerability. It's quite a topical subject at the moment. So we'll just go through some slides. So today we're joined by Stuart Stretton-Hill from Erne Mitchell, who's going to be taking us through a presentation. And then we have our very own Marina Gabas, who will be sort of talking about a bit about how we deal with client vulnerability. It's Marina's first one, and I know she's going to be amazing on this. And then just our quick disclaimer, as always, this presentation is for professional use only and is intended for educational and informational purposes. This presentation is not intended and does not constitute as financial advice, investment advice, or any form of advice. You should always seek professional advice before taking action. And our presentation today was structured and verified by Apricity, who is an independent compliance and regulation company that we work with. So we'll do our question and answer session at the end of the presentation, as we always do. We won't be taking questions as we're going along, just so it doesn't interrupt the flow of the presentation. And to do that, there should be a question and answer button at just at the bottom of your screen. It might be at the top if you change the settings around. All you need to do is type your question into the text field. If you want your question to be anonymous, there should be a little checkbox to send that anonymously. And once you're happy with your question, if you just click send, I will gather those questions and I will present them to both Marina and Stuart at the end of the presentation. Just as a bit of a pointer, if you did want to direct your question specifically to one or the other, just pop a little note in there and I can make sure that that's directed to the right person. But equally, I'm sure they can both answer those questions for you. So that's enough from me. What I'm going to do now is just hand over to Stuart and he'll start to take us through his presentation. So over to you, Stuart.
Lovely, thank you very much indeed. Let me just share my screen. There we go. So hopefully you can see my wonderful picture there on screen. Just by introduction, I am Stuart Stretton-Hill, a senior associate with Erne Mitchell, and I specialise very much in helping the vulnerable, helping those in later life, providing their families with peace of mind, putting legal solutions in place to ensure that there's the right provision for families and vulnerable clients for the future. And today I'm going to be talking about client vulnerability, what we can do to spot vulnerability, how we can help protect vulnerable clients, but also about mental capacity and how that might cross over with vulnerability. As said, if you want to raise any questions, do please pop them in the Q&A, and I'm more than happy to address them at the end of the presentation. So the very first question, of course, to ask is, what is vulnerability? It's quite a good question, really, and whenever I do these presentations I always look for some sort of inspirational quote from my friends. So I asked them what vulnerability was, and actually none of my friends tended to be that inspirational, so I turned instead to Google, and there's this wonderful quote on Google from Professor Brené Brown, which says, "Vulnerability is the last thing I want you to see in me, but it's the first thing I look for in you." And I think that's really interesting, and it really got me thinking about how we look at vulnerability, because I mean there's two parts to that quote, and looking at the first part, essentially it says, you know, we all wear masks. We don't want people to see that we are vulnerable. And I was reading BBC News, and there's some study done. Apparently 67% of people are nervous about using the self-service checkout. I thought it was just me, but it's really staggering to find that number of people are worried about using the self-service checkout. I mean, I always turn the volume down because I'm a bit embarrassed that the computer's shouting at me, and I'm worried that other people are listening to what I'm buying. But it just goes to show that I had no idea so many people were nervous about using these checkouts. So it shows that we really do our best to hide vulnerability. And looking at the second part of that quote, that's even more important from our point of view as professionals. It's the first thing I look for in you. that can be looked at two ways. It's either how can I exploit you for my own gain, or as we should be looking at it, how can I protect you from those people who are wanting to exploit you? And that's the point. As professionals, we need to peek behind that mask. We need to spot when clients are vulnerable and are trying to hide it. But at the same time, we've got to make sure clients remain at ease, because if they're feeling nervous, if they're feeling vulnerable, they don't want you to see that vulnerability. Some more definitions of vulnerability as well, and it's really a hard thing to pin down. The Oxford Dictionary says it's the quality or state of being exposed to the possibility of being attacked or harmed, either physically or emotionally. I don't know, I mean, it's not a very neat definition either there, and the FCA have tried to define it either. I don't think their definition is terribly neat, but what it really says is vulnerability can't be neatly defined, but it's not limited to elderly or mentally incapable clients. It's potentially everyone can be a vulnerable client. And so it's a case-by-case basis. You're going to need to consider everything about your client who you're seeing to determine, are they vulnerable? So to help you do this as professionals, I think it's worth drilling down to what vulnerability is. And when we come across it in our professional lives, really there's sort of two types of vulnerability. The client may be vulnerable because they can't understand the information they are being given, and that's obviously something critical in our line of work, because from a legal perspective, from a financial perspective, we are dealing with very complex issues that we need to try and boil down to their essential components to help someone who may not understand, may find it difficult to understand what we're talking about. And that is known as sort of internal vulnerability. It's an issue. I say an issue. It is a characteristic of the person themselves. A client might also be vulnerable because of external circumstances. So something might be going on in their lives that means they are prone to influence or are additionally vulnerable as a result. And just to give you some examples there. So I say internal situations, internal vulnerability have characteristics. It could be someone's age, but just because someone is old doesn't necessarily mean they are vulnerable. They might have poor language skills, but again, just because they've got poor language doesn't necessarily mean they're vulnerable. But there's a whole list of things, like as I've put up there on the screens. You know, low income, learning disabilities, where they live. You know, if you're seeing a client remotely, that might place them in a vulnerable situation because they haven't, they're not there face to face with you. English as a second language, and I was chatting to Marina this morning about this one for the presentation. I always ask clients who don't have English as their first language whether they want a translator, and more often than not they say no, I'm absolutely fluent in English, it's absolutely fine. But what struck me this morning from our conversation is if someone doesn't have English as their first language and they are in a nervous situation, a vulnerable situation, or being presented with complex ideas, it is entirely possible that they will default to their native language. And so while they may not think they need a translator present, it is potentially harder for them to assimilate the information being provided in English. So just bear in mind, it could be a vulnerability factor. Situational vulnerability, are those going to be more or less obvious? Well, they might be more obvious. You know, the threat of harm, we need to dig quite carefully into that. So, you know, is someone providing instructions to you because they're concerned that someone at home or someone in their life will harm them physically or emotionally? You need, as I say, you need to dig quite carefully on that and look out for the signs that could indicate they're in a harmful situation. And I'll come on to some of the signposts in a bit. Bereavement, huge issue in my line of work. I deal with a lot of probates, and people tend to fall into two categories with probates. Either they're the very practical, I want to get stuff done right away, here's, you know, go and get the grant, here's the tax information, off you go, action. And then 6, 7, 8, 9 weeks down the line, then it hits them. That's when the bereavement hits them and they go to pieces. Or they are clients who at the outset are very vulnerable, can't deal with issues straight off, need you to lead them by the hand and help them through the funeral and all sorts. And more often than not, I mean, I'm one of the first people people phone on a bereavement. So, you know, dad died 2 hours ago. Well, the first people you should be phoning are the funeral directors. Don't worry about me. You know, you've got weeks to sort out the legal side. But that can be how people's minds work. They will jump on, when they're going through a bereavement, they will jump onto a particular issue and focus on that. A rule of thumb I use, everyone is different, but a rule of thumb I use with bereavements is I tend to say to clients that don't take any major decisions following a bereavement for at least a couple of years. Selling the house, changing job, whatever it might be, give yourself time to bed into the new normal. Other things, loss of income, loss of employment, that's a big issue in someone's life, the loss of a job. But we don't necessarily translate that to vulnerability as a result, the inability to potentially understand complex issues that are being given to someone. So do just think these are flags that should be making you think this person could be vulnerable. They're not necessarily actually at risk of exploitation, or not necessarily actually vulnerable people, but they are flags to make you think, is this person vulnerable? I need to do some more digging. And it could be even very, very simple things. I was talking about situational vulnerability, but a child not doing well at school, that's a distraction. It distracts your mind from the things you need to focus on. So it's really about getting to know your clients, their situation and their characteristics. So as well as internal and external vulnerability, you've got also short-term and long-term vulnerability. Now, short-term vulnerability tends to be situational. Excuse me. So that example I've just given, the idea that a child is doing bad at school will be a distraction for a short period. It may be a life-changing event. It may be something very minor. More often than not, with short-term vulnerability, the client won't be aware they're necessarily vulnerable. They will be distracted in some way, possibly. But again, just because someone is going through a potentially vulnerable situation doesn't necessarily mean they are indeed vulnerable. So as humans, we often have a brilliant way of compartmentalizing issues. So going back to the executor, some executors are very good at saying, right, okay, I know what needs to be done. Yes, I've got the bereavement. I'm going to deal with that in my own time. Right now, talk to me about the tax, talk to me about the will. How do the assets pass? I need to focus on that and deal with it efficiently. A couple of weeks down the line, right, now I am going to deal with the bereavement. Now I'm going to deal with that emotional side. So short-term vulnerability can be quite hard to identify. And so it's a matter of asking those questions to a client, testing their understanding, just probing a little bit to see how they are feeling. Long-term vulnerability, we usually think of mental illness when we talk about long-term vulnerability. That's the sort of obvious one. Mental incapacity, special educational needs. The problem is mental illness carries a stigma, and it shouldn't do, but it does, unfortunately. We need to be aware that those living with mental illnesses, living with dementia, are very likely to be embarrassed, are very unlikely to be unwilling to admit that they need extra support, and are hugely unlikely to say, hang on a sec, I'm sorry, I don't understand what you're talking about. Could you repeat it, please? Because to an individual with mental capacity issues, they can be fearful about admitting that vulnerability because they think this means I'm losing control. Someone else will start taking control of my affairs, or people are going to be making judgments about me. So it's very important to deal with it sensitively and to sort of keep probing, keep offering support. It's not only mental illness. There could be other ongoing situations. I've mentioned language barriers earlier, but what about long-term medical treatment? If someone's receiving long-term chemotherapy or something like that, they may just be exhausted from that treatment, or maybe the medication leaves them a little bit fuzzy in their mind. Again, keep an eye out for these things and offer that support. Take that extra time with the client. Try to ensure that they are willing to talk about those technical issues. If they're not, say, look, can we come back and talk about it later? When is a good time for you? Particularly if someone's on medication, maybe they have their meds early in the morning, and it's a bad time to talk to them at 9 o'clock because they're still a bit hazy, woozy from the effects of the medication. Maybe after lunch would be better. Conversely, with older clients, after lunch tends to be a bad time because they want their afternoon nap. I know I do, certainly, and around 2 o'clock in the afternoon, don't try and talk to me at all. So that is, it's about picking your time, spotting when's the best time to speak to vulnerable clients so you can help them understand all the issues. So I've talked a little bit about things to look out for, but it's a matter of looking for those things. What might a client say? What might they do? Things a client might say, and I come across this a lot, and particularly where there might be undue influence from a family member, is my daughter's suggested I should make a will. She tells me that I should do this, that, and the other. Now, okay, that's not necessarily undue influence, but it's there flagging to me, okay, well, actually, do you want to make a will? What are your wishes? Why has your daughter said you need to make a will in these terms? Is it for your benefit, or is it more likely for hers? So just spotting those nuances in the way the client is talking. Things a client may do as well. Lack of eye contact is a particular one, particularly if you're getting into technical issues and the clients are shuffling, looking down at their papers or looking out the window a lot or not paying attention. Why are they not paying attention? Is it because the issues are complex? Is it because they don't want to talk about it? Does it make them feel uncomfortable? If you identify those issues, if you spot that body language, drill down. Ask for more information. So, do you understand this? Could I put it in a different way? Do you want me to write you a letter instead, maybe? So it's keeping an eye out for these signs, and they can be very, very subtle, and it really can be quite a challenge for us to spot them. Don't be afraid about asking a colleague perhaps to come into the next meeting. More often than not, with 2 people present in a room, one person's going to be doing all the talking and taking notes and chatting away. The other can be looking out for those signs, saying, well, did you notice actually they shifted uncomfortably in their seat when you were talking about their husband? It can be really helpful just to have that second set of eyes. So I've talked a lot about vulnerability. I've touched on mental capacity. It's really important to realise they're not the same thing. And this is a really, really good diagram, one of these wonderful Venn diagrams that we all did at school. And I confess I've shamelessly stolen this from Tim Farmer, who is an absolutely wonderful expert in mental capacity assessments. If you haven't bought and read his book, Grandpa on a Skateboard, I hugely recommend you do. He's really the guy for this, and I promise I'm not being paid to promote him. But I think this is a really good example or diagram rather, to help us understand how capacity, mental health, and vulnerability might be linked, but don't necessarily overlap in all cases. So let's look back. I said vulnerability might be due to circumstantial issues. So it could be someone who has a child doing badly at school. That doesn't mean they have a mental health issue or a capacity issue, but they could still be vulnerable. Just because someone has a mental health issue, they've got learning difficulties maybe, doesn't necessarily, again, mean they're vulnerable. It all depends, what are you talking to them about? If you're talking about very simple concepts and very everyday to-day life issues, then they're not going to be vulnerable. They're going to understand those. But as the complexity of the matter increases, the more chance that vulnerability and the mental health are going to overlap. And equally with capacity, it's very tempting to make that assumption. I'm working with a client who is living with dementia. They must be vulnerable. Maybe not. I had a lovely elderly client who was 101 when she died, and she had dementia. But boy, could she keep me on my toes. She would go through the bank statements and so forth that we were helping her as her attorney. She'd go through the bank statements, she'd tick off payments here and there and said, okay, so that's for your costs. What have you done this month? And would challenge, saying, what things have you done for me this month? But when it came to personal care, awful. She couldn't understand the risks of not taking a medication, the risks of living alone at home on her own. So she had capacity, but she wasn't vulnerable in a financial legal context because her mind was sharp as a pin. And again, you can have all three. If you've got mental health and capacity issues, likelihood you're going to be vulnerable. That overlap in the middle probably should be a little bit bigger, but it doesn't necessarily mean all three issues are present with everyone. So I was going to talk more about mental capacity, having looked at vulnerability. I want to talk more about mental capacity and these are the practical issues that you might come across in your day-to-day professional lives, and really to drill down on capacity from a legal perspective as well. So the Mental Capacity Act, thankfully, has come on a lot since 1985. The Mental Health Act back in 1985 basically said, you've either got capacity or you don't. Simple as that. The laws moved on. 2005, Mental Capacity Act was drawn up, came into force 2007. And it's got these wonderful principles in the Act. And one of the major principles is you must never assume an individual lacks capacity. You should always assume they have capacity. And you can't change that assumption just based on someone's appearance, their age, their behavior, their condition. It's all about focusing on the individual. What is their situation? As I mentioned, even if they don't lack capacity, they could still be a vulnerable person. So it is important to identify the ability for the client to take decisions, whether they do actually have this capacity, and to support the client to take decisions as much as possible. Now, you might be saying, well, how on earth do I judge if a client has capacity? And the test set out in the Act has this wonderful, I love this phrase, and I'd love to meet who drafted it, but basically the question is, does an individual have an impairment of or disturbance in the functioning of the mind or brain? What a lovely phrase, and it gets me thinking about, when we think about mind or brain, we're talking about a physical disturbance in the electrical communications in the brain itself. Speak to neuroscientists about this, and it's really fascinating how the brain itself works. Or in the functioning of the mind, the slightly more esoteric concept, the thinking ability, the logical deduction. You get into really interesting discussions there about the separation of the physical from the mental. I rather like that, but I'm not going to talk about that in depth today because I can go on for hours. But the fact is, does someone have an impairment or disturbance function of the mind or brain? That's question one. If so, move on to question two, which is, can they take the decision in question? And this is a really important difference under the Mental Capacity Act and the Mental Health Act. Can they take the decision in question? It's not a blanket black or white, someone has capacity or they don't. It's capacity is tested for each individual decision someone needs to take. Do they have capacity to pay a gas bill? Yes, fine. Do they have capacity to make a complicated tax planning will? Maybe not. And to decide if they can take the decision, you run through this four-stage test. Can the individual understand the information they need to take the decision? Can they retain that information long enough to reach a decision? Can they weigh the necessary information to form a decision? And can they communicate their decision to you? So understanding, that's really testing, has the individual absorbed the information? Do they really understand what it means when I say making a will? Do they understand what a will is? Do they understand it comes into effect on death? Can they retain the information long enough? It doesn't have to be a long time. It just needs to be long enough to reach an informed decision. So the question is, do you want to make a will? Okay, well, I understand what a will is. I understand it comes into effect on death. Yes, at this moment in time, I do want to make a will. 20 minutes down the line, I might say to the client, now we spoke about making a will. They may say, well, no, we didn't. I don't remember talking to you about making a will. Well, that's okay. They've formed the decision. They've realized at that moment in time, 20 minutes ago, it's an important thing to do. Can they weigh the information necessary to take a decision? So can they balance the risks? So in my client's example, do they understand the effect of the intestacy rules if they don't make a will, who their estate would go to? If they're happy with that, fine, they don't have to make a will. If they can communicate their decision, I don't want to make a will in that case, I've thought it all through, and for this 20-minute period, I am satisfied, I don't want to make a will. It may be, I have to talk to them again in 20 minutes time and ask them the same questions. Do you want to make a will, and run through it? Now, if their decision is different, and they say, actually, no, I do want to make a will, I've weighed the risk, then it gets a little bit trickier. Have they changed their mind, or have they not understood everything I provided to them? So you really need to drill down into this test. Can the individual communicate their decision? Now, that's not just verbally in whatever language you choose. It can be through aids. It can be using one of those light writers. It can be typed. It can be written. It can be by pointing at symbols, sign language, whatever it might be. The important thing is the individual must be assisted to communicate their decision. The point about this decision making, the point about it being decision specific, it's also time specific. So at that moment in time, can the individual take the decision? If not, can I see them tomorrow? Can I see them in the afternoon? Can I see them next week, when they might have capacity to make a decision? So don't just abandon all hope that someone lacks capacity just because at that moment in time they were unable to take a decision. It is a complicated area. You know, I've been doing mental capacity law for quite some time. There are still issues I will come across where I don't know. It's really tricky to say. If there is doubt, seek an expert opinion. Get a medical expert involved, and they will run through this mental capacity test, and then you are protected. If you do go ahead and purchase that annuity or invest in that pension, or whatever it might be, you are protected knowing that there's a mental capacity expert saying at that moment in time the individual could understand, weigh and retain the information long enough to reach the decision. Bear in mind, you mustn't assume someone lacks capacity just because they want to do something unwise. And you know, I had clients who loved to gamble away lots and lots of money, and she was a really interesting client because she knew the value of small sums of money, but not large sums of money. So if you gave her £10, you could understand she could take it down the track, and if she gambled away and lost it, she wouldn't be able to buy a supper that evening. But if you gave her £100,000, she wouldn't understand that if you gamble all that away, she wouldn't have a house to live in anymore. So it can be a subtle test, this unwise decision. It's all about making sure that the individual understands the risks of taking a decision in that way. And just because they want to do something daft like go on a world cruise at the age of 90, if they understand that there's health risks and a risk of not being able to get to a hospital and so forth, if they still want to do it, that's fine, provided they understand the risks. So spotting loss of capacity, it's a lot like spotting vulnerability. And if you spot vulnerability, you know, you're likely, or sorry, other way around, if you spot mental capacity, you may be likely to spot vulnerability issues. So these are the sorts of things to look out for, and it's just a short list, but there's lots of other things. Be aware of scripted answers. So repeat questions in slightly different ways. One of our team assistants, her father was very clever. His wife sadly was living with dementia, and he took her along to all the mental capacity assessment tests at the local hospital. And then sadly she died, and he actually ended up living with dementia as well. But he was very clever because he went along to these mental assessment exams, and he'd remembered the answers that his wife had given about, you know, what is this fruit? It's a banana, or, you know, who was the president on prime minister on a certain day? This and this. He'd remembered all the answers to the same questions they were asking. So, yeah, on the face of it, he had capacity. He could answer the questions. So just beware: has someone been prompted, been given a script? Can be a difficult thing to spot, so ask the questions in different ways. Watch for repetition of sentences, words and questions. So if you ask a question, be aware if the client sort of asks it back to you, because what they may well be looking for is a prompt from you about how they should answer that question. So if I say to a client, you know, do you want a will? And then they say, do I want a will? And I might subconsciously be nodding like that, and they go, oh yes, of course I want a will, because they've picked that up from me. So, you know, ask a question slightly different ways. Is, you know, what's the risk of you not having a will? Now, if they can't answer that, then think about whether they've got a capacity issue there. Being aware of loss of engagement during conversation. Is a client glazing over? I mean, you might be glazing over this presentation. I don't know, I can't see you all, but spot if they are beginning to phase out, if they're looking out of the window, if they're distracted by something that's going on. Why is this? Is this a short attention span? Is it an ADHD issue? So do what you can to get the person back in focus. Again, think, could we postpone this meeting to another day when they might be more focused? Test recollection of recent events. You know, oh, I mentioned to you about making a will. What are your thoughts about that? Did you mention making? I don't remember that. You know, it's a really good way of that sort of second part of that test, can they retain the information long enough? Storytelling is a really good one. A lot of my older clients do love to tell stories, sometimes because they're lonely, but sometimes it's because they are struggling to recall something. And I was really lucky to meet Sir Terry Pratchett, one of my favourite authors. He was, I think he was absolutely fantastic, but he had very advanced, very particular Alzheimer's. And I was having a conversation with him, and we were talking about one of his books. And he started telling a story about when he was a young lad doing a raid on the local pub. I thought, this is completely irrelevant to what we were just talking about. And it's rambled on for about 5 minutes and then came back round to what we were talking about. And I suddenly realised it's because he was struggling to remember a particular word. And through this story gave him time for the brain to eventually latch onto what he was trying to say. So look out for that storytelling. Is it relevant to what you're discussing? Focusing on specific details as well. You know, that might just be a very detail orientated client, but if a client is particularly focusing on a specific issue, it might be certainly in the will's case, you know, how does my daughter benefit from this will? What would happen if she died? You know, why can't I give her more? Why can't I give her less? If there's lots of repeated questions there, that might be an attention disorder thing. It might be a risk of vulnerability. It might be some indication that the mind isn't quite working properly and focusing or looking at the bigger picture. So hopefully that helps. Just some pointers there to spot capacity. What can you do to help clients who lack capacity? Indeed, actually, some of these also apply to helping clients who might be vulnerable for other reasons. But if you need a meeting with a client, they can't come to the office, actually, is a video meeting appropriate? It might not be. You can't really judge capacity very well over a video. So think about having them come into the office or going out to see them. If they are coming to the office, think about the layout of the office. Clients living with dementia, it can affect their perception. So things like black mats on the floor could appear to be a hole to them. They may be anxious about stepping across the threshold because they're worried they might fall down this hole. Patterned walls can look like water or rain coming down the inside of a wall. Carpets with wiggly lines, is it a pit of snakes or something? That's how the mind could be affected by dementia. So you know, if you've got a client who seems nervous or hesitant about walking through the office, assist them, help them down the corridor, find out what's going on. Face-to-face meetings, think about distractions, think about the layout of the room. I used to see clients in the office. I'd have the window to the outside world behind me. We had a car park behind us where everyone kept reversing into this lamppost that was there. Huge distraction for clients living in dementia because they're constantly, oh, what's going on out there? That looks really interesting, and not focusing on what they're being told. Very simple tactic, switch the room round. I've got a blank wall behind me. The client is focused on me. Minimize background noise, a slightly obvious one there, but it's very easy for people with hearing issues to get distracted by other conversations that might be going on. Entering the individual's reality is a bit of a tricky one. Some experts recommend it, some experts don't, but it's about sort of minimizing trauma for an individual. So if you have a client who has recently lost their husband, but is living with dementia and can't remember that fact and is quite convinced their husband's just out and is going to be back for tea in 20 minutes. If you say to the client, but your husband died last week, two things are going to happen for that client. They're going to feel very emotionally distraught. One, you have just told them in their mind for the first time their husband's died. Secondly, you're saying to them, you didn't remember that fact. Imagine how traumatic that must be for the individual. So instead, it's okay to enter their reality and say, oh, okay, well, yeah, he might be back in 20 minutes, but let's talk about you. Steer the conversation on, because probably the memory will come back in, oh, yes, husband is dead, and you can focus on those facts. As I've mentioned a few times, can you postpone the meeting to a different day, a different time, when they may be feeling better? Other things, particularly in conversation, be friendly. Kind of obvious, I would hope, but it's easy to appear aggressive. Make eye contact, ensure the individual is focused on you, is understanding what you're saying. Be really consistent with your body language, and that's a really interesting one. I mean, you know, you can lead a client so easily with your body language. I mean, you can imagine, oh, you should buy an equity release, or why not invest in a pension? Which is the client going to do? Speak clearly, calmly, slightly slower. It's very, very easy to jabber on, particularly if it's something we're keen on. I love talking about inheritance tax, and I could talk about it for ages, but it's just that matter of taking a breath, pausing, using short sentences, avoiding jargon. Don't interrupt them, don't hurry the individual as well. It's really tempting to help them get to the end of their sentence, particularly if it's been a long meeting. You want them to get there. But if you do that, you're potentially leading them to an answer, leading them to something maybe that they don't want. Always speak to the individual, even if they've got a translator or someone present to help them. Always speak to the individual. They are your client. There's a wonderful example from a lovely lady called Alison Hesketh, who runs this wonderful business for helping older clients and deal with life, really. And she tells this example of a lady who lost her husband and was completely at sea in dealing with finances. She couldn't even figure out how to buy a fridge or anything like that. And Alison helped her very much through the loss of her husband, took her down to B&Q at one point to buy this new fridge. And the sales assistant was speaking very much to Alison rather than to his client, this lady who's buying this fridge. He said to her, would the lady like dropped out there a second? Are my slides sharing? No, they're not.
Sorry, we've got you back, Stuart.
You've got me back. And can you see my slides all right there?
I can indeed.
Lovely. Sorry about that. Sorry.
That's about right. Late, carry on.
So yes, as I said, this sales assistant was talking very much to Alison rather than the lady. And he said, would the lady like to buy an Indesit or a Hot Point or whatever it was? At which point she piped up and said, the lady can make up her own mind. Thank you very much. And it was at that point Alison thought, brilliant. My work here is done. She's got the confidence to talk for herself. But I think that's the thing. It is much better to speak to the individual, spot their cues, spot their visual cues. Use diagrams, use objects, use visual cues to help the client understand what it is you're talking to them about. A box of chocolates is a great example, particularly when distributing assets under a will. What number of chocolates do you want to give to mum? What do you want to give to husband? This, that, and the other. Really, really useful things using visual clues. Much easier than just using words. In awesome conversation, tailor your questions, but don't lead your client. Use short and simple questions. Try not to ask why. Why is a conceptual issue. It involves a lot of thought process. So, if someone said, my son wants to be, is going to be my attorney, and you might say, I trust him. Oh, well, why do you trust him? That's a lot of thought process. Rather than saying that, say, what does he do that makes you trust him? What if he says, he helps me look after my budget? Brilliant. That's a good practical thing he does. But it can tease out where there's other issues. So if the answer is, as I have with one client, well, he tells me I should trust him. There's a risk of influence there. So it's a really good way of teasing out influence. Don't use figures of speech. People living with dementia can take things very, very literally. And avoid unreliable questions. Don't make a statement and invite an individual to confirm it's true. Don't give forced choices. Do you want to do this or this? Try not to use things which have too many negatives. It can be really confusing. I think I even got that one wrong. Chains of events as well. Running through a chain of events can be quite difficult for an individual to follow. Open questions are good, but be aware, say, that the mental capacity, the mental effort it might take to follow an open question through. So close those questions down quickly if needed. But again, try not to lead a client to the answer that you think is right for them. Taking instructions from third parties. This is an area that can be rife with problems. So if you have a client you fear they might be vulnerable, they might lack capacity, can you involve a third party subject to confidentiality? What I wanted to talk through here really was the issue of whether you can rely on the authority the third party has presented to you. So anyone could be given consent to discuss issues with the third party, and that's either through an agency agreement, a general power of attorney, or literally just verbal consent saying, yeah, I'm happy for you to speak to my son about this. But bear in mind, if your client lacks capacity to take the decision in question, the authority of that general power of attorney, that agency, or that verbal consent ends. Because if someone lacks capacity, the only way an individual can carry on taking decisions for them is through a registered enduring power of attorney, a registered lasting power of attorney, or a deputyship. Really important, I'll talk about this in a little bit more detail, but if you've been presented with an enduring power of attorney, but the donor of that power has lost capacity, this will pause the authority of the attorney under an enduring power of attorney. So just be aware of that, as I'll talk about that in a little bit more detail. So I just want to run through on a practical basis the things you should be looking out for when presented with one of these documents. Hopefully everyone is familiar with what a financial power of attorney looks like. But it's just a matter of looking for some of the obvious things. If you're given an LPA and someone wants to act on behalf of your client, make sure it's the right LPA. I know it sounds daft, but there's the two types. There's the health LPA and the financial LPA. And I have had some attorneys successfully instruct banks to cancel or create standing orders off the back of a health and welfare financial power of attorney. So just look, make sure it says financial decisions on the front. Make sure it is registered. This stamp should appear on the LPA, that where it says validated OPG in those dots, that is a punctuation, a puncture mark that goes right the way through the whole LPA. Be aware if there's any pages tagged on the end that don't have that puncture mark through them, they might not be part of the LPA itself. If that stamp isn't on the LPA, it is not valid. An LPA must be registered before it can be used. Another slightly obvious one, make sure you're dealing with the right people. Make sure the donor is your client. At section 1, it is your client's details there. And the attorneys are the people you are dealing with. It's not someone else. Make sure their names and addresses are correct. If there's any doubt, seek additional identity documents. How are the attorneys appointed? Is it jointly and several, jointly, or jointly for some decisions and severally for others? If you have one attorney, if more than one attorney has been appointed, you have one of them coming to you and it's a joint appointment, you cannot take instructions. If one of the attorneys has died or lost capacity, disclaimed or is bankrupt on a financial power of attorney, then a joint appointment will fail. So be very aware of that. Joint and several, you know, that can introduce problems where the attorneys disagree on what they might want to do. But just be aware, as I say, those issues which might prevent an attorney from acting. Jointly for some decisions and jointly and severally for others, I always dissuade clients from picking this option, but if they do, be very, very careful about the wording of this option. It can be quite difficult to identify when something should be taken jointly and when something should be jointly and severally. Examples of this, for example, I had a client who had in their LPA, I want my attorneys to act jointly and severally for all decisions worth more than £1,000. Well, okay, if it's a transfer of £1,000 of cash, that's all right. But selling a car that might be worth 900 quid, might be worth 1,200 quid, how's the decision got to be taken there? It can be really tricky to spot. So do just look out for those restrictions. If it's a replacement attorney you're dealing with, make sure they've got the authority to act. The LPA should have been sent back to the OPG and the OPG should have stamped it saying that the primary attorney can no longer act. The only ways where any situations in which a replacement attorney can act is death of the primary attorney, permanent mental incapacity, disclaimer, divorce, or bankruptcy. Those are the only situations which will cause a replacement attorney to act. If the donor revokes the authority of a primary attorney, that does not kick a replacement attorney into acting. So do just be very, very aware of whether the replacement attorney can instruct you. Again, when can the power be used? There's these two boxes here. If they tick the top box, you're usually all right to rely on what the attorney is saying, but if they tick the bottom one, only when I don't have mental capacity, you need to ensure that the donor doesn't have mental capacity to act. And you cannot take instructions from the attorney if they still have the capacity, if the donor still has capacity. And look very carefully at the preferences and instructions. In the instruction section, there may be an instruction there preventing the attorney from doing something, e.g. they may be prevented from buying a care annuity. Preferences, you know, this is just guidance to the attorneys, but you should be alert that if an attorney is doing something that is contrary to a preference in the power of attorney. For example, there may be a preference there saying, I do not wish ever to move into a care home. If an attorney is moving into a care home, is it actually in the individual's best interests? So perhaps push back, question why the attorney thinks it's in the individual's best interests. Look for these continuation sheets. They may well have a lot of information on them, restrictions, instructions in those continuation sheets. Be aware that sometimes they might get misplaced by attorneys. If there's a continuation sheet that says something that they don't like, it might just fall off the back of the copy you've been given. So make sure you've got a complete copy of the document. Enduring powers of attorney. This is what an enduring power of attorney looks like. There's less and less that you're likely to come across. Be very, very aware. An enduring power of attorney can be valid from the moment it is signed. It doesn't necessarily have to be registered. But if the donor of the enduring power has lost capacity, then the authority of the attorney under the EPA ceases until the EPA is registered. And similar things as before, look about who the donor is. Is it relating to your client? Who are the attorneys? Are they the right people? Check if they've been appointed jointly or jointly and severally. What authority do they have? Is it general authority or only to do specific things mentioned in the power of attorney? So really drill down and look at the document. When was it signed? And if it was signed after 30th September 2007, it's not valid. Also, are there any restrictions? Same point as the LPA. Are there restrictions there preventing an attorney from doing something? Often under enduring powers of attorney, donors would write that they don't want their attorney to act unless they lack capacity, unless the donor lacks capacity. Slightly conscious of time, so I'll just whistle through a deputyship order as well. You may have come across deputyship orders. These are what they look like. Basically, the deputy can only do what they're permitted to do in the court order. So the redacted bit there is the person who is being appointed as deputy. So check that the name there is right. What can they do? So general authority in this case to take control of property. Section B there, they're allowed to make provision for anyone that they might have made provision for example, a spouse or a child. The attorney here can make, the deputy can make gifts to charity or and so forth. If those powers aren't in there, the deputy wouldn't be able to do those things. Notification, be aware that it is possible for the donor or for anyone to apply to overturn a deputyship order. So if you've been presented with one, is it actually a valid order? Has there been a subsequent order that's been made? So just wrapping up briefly, I've touched on best interests. I think just remember, if you are accepting instructions from an attorney, it is their duty to ensure that what they are doing is in the individual's best interests. Best interest is not substituted judgment. It's not what would the individual done if they had capacity. It's a balance sheet approach. What are the pros? What are the cons of the decision being taken? The attorney should be considering what the individual would have done, but balance that against the views of others, how the decision impacts on them, whether it's restrictive of their freedom. And from your perspective as an advisor, perhaps push back and say, really, is this in the person's best interest? You know, you're thinking about spending all this money on whatever it might be. Test whether the attorney thinks that what they're doing is in the individual best interest. If they haven't even done it, then I would, if they haven't done a best interest assessment, then I would hang fire from acting on their instructions. Finally, workplace practice. I think Marina's going to talk a little bit more about this, but these are the sorts of things to be thinking about when coming across mentally incapable clients, the systems have in place to help mentally incapable clients and vulnerable clients as well. You know, have a policy in place, use plain English, don't have inflexible policies, ensure you've got specialists who are able to understand and communicate properly with clients. Remember to signpost if you have fear that someone's at risk of financial abuse. That might be social services, a doctor, even the police. But be aware of your duties under the GDPR and Data Protection Act. Above all, just know your client, get to know them. There's nothing more valuable than having that cup of tea and a good long chat. That's all I was going to cover today. Very happy to answer some questions at the end of the session, and hopefully I've left Marina with enough time.
Perfect. Thank you very much for that, Stuart. I've definitely learned a thing or two. I thought that was very informative. just in case anybody saw Marina and I jump out of our chairs halfway through, that wasn't anything to do with what you were saying, Stuart. We had something fly at the window quite with some force. I've been assured that it's okay, but just a bit of an explanation about that. So yeah, so without any ado, what I'm going to do now is just hand over to Marina, and she'll take us through her presentation also. So over to you, Marina.
Thank you, Anthony, and thank you, Stuart, for your presentation. It certainly was very interesting. I'm now going to share my screen, and hopefully you can all see this okay. And to take things on from where you have been, Stuart, I'm going to perhaps talk about vulnerability from our point of view, from financial planners, and how we experience it. The FCA has defined 4 categories for vulnerability. The first one is health, and that's perhaps living with a short, long-term illness, living in pain simply, or battling an addiction. And that's when really an everyday task can be a greater challenge. The second one is life events. I think the ones we come across the more often are bereavement, redundancy, perhaps breakup in the relationship, becoming a carer, or being a victim of a crime. And that is the sort of events that could put us in a vulnerable position. The third one is resilience, and that's really our ability to cope with life events. And that varies from person to person, but it can be worsened by things such as low income and other factors where without support, the situation quite quickly worsens. And the fourth category is capability. And that's really where, if, for instance, understanding the service we provide, the products we recommend, or the literature that we're going to present to the clients, if that's difficult to understand, if that's overwhelming and compounded with factors such as low confidence or English not being the first language, this can also lead to very vulnerable situations that we're having to identify. And of course, we've got to be aware now that with recent studies, almost half of all adults could be considered as vulnerable in some ways. The key for us is to make sure we've expanded our understanding of this vulnerability situation as much as we can, and also is to make sure that our role as planners is to provide a positive outcome for all clients, regardless of their individual situation. And this is where it's important to make sure we identify things correctly. However, it's not easy in our world, like in any professional world. The first reason why it can be difficult is where clients don't even consider themselves to be vulnerable. That could be a family becoming a carer and having to deal with so many issues that they're hardly taking time to think about themselves. But then if they're having to make decisions about their own financial position, they may be distracted. Okay. The second one could be that they're aware, but they find it difficult to express themselves. It's often associated with a negative situation, and it's not something pleasant for them to talk about. Or it's something that they worry once they've talked about it. You might have a reaction, or you might treat them in a way that they're not too happy. If a client is battling addiction, they might be worried about judgment thereafter. Or simply sometimes we've realized that the client didn't say anything purely because they didn't think we could adapt our processes at all. So well, there's no need at all. And let's talk about adaptation next then. If when seeing a client, we think, does our normal process fit, or do we need adapting? If the answer is yes, then of course we need adapting. And this is how, to kind of echo where Stuart's going, we would go about it. We need to assess the situation, get the right guidance to understand the causes, the nature, the scale, characteristics, etc. And then we need to really understand the impact of the situation, positive or negative. Only once you've made this assessment, you can really decide on the best actions and the options you can offer for an appropriate adaptation. And all of this is wonderful, but if it stops there, then it's nothing. It needs to be recorded. It needs to be recorded properly and at different levels, so that it's not just with the advisor. If a client has expressed their perhaps normal reports or letters are a little bit useless to them because they can't see very well. And the advisor says, yeah, that's not a problem. We'll always make sure that we send an adapted font and we'll print it a bit bigger for you. It's wonderful. If they haven't passed that information to their administrator, and the administrator sends a report which is with the normal company funds, then it puts the client in a bit of a difficult situation. Are they going to call us and say, oh, but my advisor said that we would do this and you haven't? Is it going to make them feel a bit embarrassed, or they're going to say, oh yeah, that was nice of them, but that didn't happen for us? It's not a positive outcome then. Okay, so I think what we need to think is that as a minimum, the adaptations need to be clear for everyone in terms of meeting formats and communications, so we always know we've adapted well. And that's really the sort of things that at company levels we need to make sure we can do to best serve our clients. And that also comes with company culture. It cannot just be a policy on a piece of paper that we all follow. And for us to promote a healthy culture, we need to make sure that the advisors feel at ease, that if they encounter a situation they're not comfortable with, we're open to any new adaptations we've not thought about already. We need to make sure that we've got the right processes in place to support them also, and they might be going through some personal stuff themselves. So it's making sure that we've got the right values in place, and we've made it clear with the team. It's not a black and white matter. It's also making sure that we really help with the development of soft skills and have the right training in place. Often we find that if a new client comes to us, whether it's themselves inquiring or their attorneys or a solicitor sending that client to us, if there is a vulnerability beforehand, we're told about it and we can prepare almost. Where it becomes really delicate is if an existing client find themselves in a vulnerable position all of a sudden, and where we know them, we have our habits, we know how to communicate with them, how to deliver information, all of that can change, and all of a sudden we're having to deal with a person we know in a new relationship, and that can be quite tricky. We need to make sure we get this right, and we can't preempt all scenarios possible. That's not realistic. So the best way to not be surprised by a situation is make sure that we've educated ourselves, we've read about it, we've seen as many webinars as we can, or read as many articles as we can, and always get the help of companies and persons such as Stuart, where their knowledge is invaluable for us. I will very quickly touch on the point of view of the FCA, where as regulated firms, we have to abide by the TCF outcomes. Treating customers fairly is a outcome-based concept, obviously designed by the FCA to make sure that regulated firms behaved in a way that is expected to, but this has become more topical lately, where vulnerability has become more obvious. The first concept is that a customer must be confident that they are dealing with a firm where treating clients fairly is central to the company corporate culture. The second one is where the product and services that are marketed and sold to the customers in that retail market are designed to meet the needs of the group that we've identified and targeted accordingly. The third one is where consumers are provided with clear information and always kept informed appropriately before, during, and after the point of sale. The fourth one is for consumers where they receive advice to make sure that the advice is always suitable and takes into account their personal circumstances. The fifth one is where consumers are provided with products that perform as firms have led them to expect, and that the associated service is of an acceptable standard and as they have been led to expect also. And the last one is where consumers must never ever face unreasonable post-sale barriers imposed by the firm to change product or switch a provider, submit a claim, or make a complaint. And that's really our angle of things. So to conclude very quickly, I'd go on to summarize and say that for us, what you need to take on this is that vulnerability nowadays affects a much higher proportion of clients than ever before, hence why it has become such a key focus for the FCA. It's also the importance of dealing with vulnerability well for all staff. That's paramount. And this is where, again, where getting the right guidance is very important. And finally, is that all of that, it's only possible if you've got the right processes in place and if the company culture is embedded correctly. Remember, some clients may not even consider themselves to be vulnerable. So that's me for my slides. Thank you very much for listening to me. I'm conscious we're sort of coming near the time. I'll pass the presentation back to Anthony and stop sharing my screen and see if there's any questions. Thank you very much.
Thank you, Marina. I thought that was great also. What we did, we're quite conscious of time, but as we start a little bit late, we'll get through a couple of questions anyway, as there's a few come through. As always, the ones that we don't get chance to answer, I'll send a little follow-up email afterwards, and I'll get Stuart and Marina to answer those separately. So the first one I'm going to ask to you, Stuart, if that's okay. And the question is, what can we do if we have concerns that the attorneys are not acting in the best interests of the client?
Yes, well, yes, as I say, a tricky one there.
I think we've lost the audio, Stuart.
I think it's,
oh, we got you back.
A matter of vision. Oh, you lost the audio.
We've got it back.
Oh, good.
Yeah.
Oh, I know what it is. There we go. Sorry about that. Yeah, okay. As I say, it is a matter of testing how the attorneys come to the decision. You know, what factors have they taken into account? Now, you know, if they haven't done that balance sheet approach, if they can't show you a note saying I've thought about this, and this, then I would say, look, you know, refer them back to their duties under the Mental Capacity Act, refer them to the Mental Capacity Act Code of Practice. It's a big document, but actually a really good read, lots of practical advice in there. And say, look, I'm not going to act on your instructions yet. You come back to me and show why you think it is in best interest. Now, if they provide you with a sort of slightly manipulated best interest test, then it is really a matter of thinking it through and forming your own view about what's potentially in the client's best interest. Awkward conversation to have with an attorney, I know, but at the end of the day, if there's a disagreement on what is in someone's best interest, the Court of Protection is there. An application can be made to the court for it to determine what is in the client's best interests.
Thank you, Stuart. We'll ask another question, and we've had this asked in a couple of different ways, so I'll try and summarize it as best as I can. But obviously with especially in our industry, where the advisors are trying to assess vulnerability and client capacity, a lot of the decision making can be down to the advisor personally. And what we've seen from a lot of companies and sort of the systems that we use is the use of questionnaires that can be presented to the client before you have meetings or going through with them. I just thought, Stuart, from your perspective, what would be your view on doing that? I know it takes a lot of sort of the emphasis on the advisor trying to make that decision on whether or not the client's vulnerable, and a lot of these questionnaires are based on kind of psychological questions that have been pre-vetted. So I just thought it'd be interesting to see what your views might be on that, Stuart.
Sure. No, I mean, questionnaires are a good start. Certainly, I certainly wouldn't rely on them alone, particularly if there are issues that are highlighted in the questionnaire. I mean, there is nothing better than meeting a client face to face and forming that view personally. And when I say face to face, preferences in the same room together. Judge that body language. Are they shifting uncomfortably in their seat? That sort of thing. I think the answer is it's a good pointer. I wouldn't rely on it alone. I'd always say see the client, drill down on those questions, and maybe get views from a trusted third party. So if you've got someone on file who the client said, yeah, I'm happy for you to speak to, son, daughter, carer, whoever it might be, just challenge with them and say, you know, these are some of the answers I've been given. What do you think? Yeah.
Perfect. No, that's brilliant, Stuart. Thank you. Well, we'll wrap that up. There's a couple more questions which we haven't had time to answer, but as I say, I'll present those to both Marina and Stuart to go through, and I'll follow those up with an email at the end. Just as always, to mention that the video and the webinar has been recorded, so I'll upload that to our YouTube channel, and that will also be hosted on our refreshed professional connections page, which is now solicitors and accountants. You can find that by going to our website. That will be updated quite regularly now as well going forward, so there'll be lots of useful information on there as a sort of one-stop shop for information for accountants and solicitors. We're going to take a bit of a break over the summer with some of the webinars. There'll be a few things coming up, so those will be presented on the solicitors and accountants page. But the next scheduled one is on the 5th of October. That's going to be about what financial planning is. We'll be busting some myths around financial planners. I know for some people they can have a bit of a bad name and a bad reputation, so we'll be busting a few of those myths, just explaining a bit more about what we do and how as a firm we've sort of adapted and what we do these days. Then on the 7th of December, we're going to do a sort of different type of webinar. It's going to be hosted by Adam, and that's going to be a financial review of the year. So as we already know, at the beginning of this year, it's markets and things have been a bit unstable, and there's been quite a lot going on. So it'd be interesting to sort of get Adam's take on that over the year and see how kind of things transpire. It might all be lovely by the end of the year, hopefully, so it'd be a bit more positive. Yep, so I'll wrap it up from there. As I say, that video will be up online by the end of the day, hopefully. I just want to thank Stuart for joining us again, and thank you for Marina. Presentations were really good, I thought, and hopefully we'll see you all on the next webinar.
Thank you very much.
Cheers.
Thanks, Anthony.
Take care. Bye bye.
Bye bye.